video for one, okay, I know what I did. I fully admitted it, blah, 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 whatever. But you're here to prove truth, correct? That's what all this is about.
Right.
The video, you can't even see my face on the video. For one, that shouldn't even be used as evidence. Two, what's to prove that blood sample they took is actually mine? They got a video of it on the site, correct? Yes, I got a scar from it, I've admitted to it and everything else. But as far as them proving it, is there video evidence of them actually taking that sample? There is not. There is a picture of it, yes. But there is not video evidence from the time they got on scene to them going in and taking it. That is hearsay. How can you use an opinion against me and then send it off? Who's to say the samples that man got were even mine?
Well,
I'll
answer that question. At this level, at this point in time, Mr. Murphy made a motion to directed verdict in these matters. At this point, now that the state has rested, my responsibility is to determine whether or not for each count the state has put in a prima facie case, looking at the evidence in favor of the state, giving inferences to the state. That's what I must do under the law. In this case, Detective Bentley testified that he was called to the scene of Armageddon Firearms on a report of a burglary. He got there, he observed, he got there, he met the owner, Mr. Cool, provided him with keys to get in the front door. He opened the door and observed that the place was somewhat chaotic. Things were on the floor, the windows were broken out of the door, and it appeared that in fact the place had been entered. Mr. Cool indicated that in fact to the detective that in fact they had video, and they retrieved the video, which was exhibit number 2. Video was shown to the jury. It clearly showed at 9:37 in the evening someone entered into the, or beat the glass from the front door, came through that where the glass had been beaten out of the door, went in, and which was amazing to me, was about 2 to 3 minutes, that person carrying a bag, carrying a framing hammer, which left in the middle of the floor, removed 18 weapons, magazines, and ammunition. They went out the back. Person left, there was left a blood stain on the steel chair that was the person would use to stand to pull some of the things off the wall, and left through the rear. And like I said, 2 to 3 minutes, and they were in and out. Among them was a 22 caliber Ruger pistol, a 22 caliber Walther, a 5.56 M16A2, and other weapons. The detective indicated that the crime scene folks for the sheriff's department came in and they collected various samples, including samples of blood taken from the stool. They were shipped to the crime lab, and the analyst at the crime lab, Mr. Noggle, indicated that in fact he analyzed those for DNA and matching it to a CODIS hit, which was Joseph Jakubowski, whose DNA was in a CODIS. That was the first time your name came up.
And see, how do I know that? How would they know that? See, my question is, wouldn't proof be take a swab in front of them?
The proof is been shown to the jury, and I don't know what they're going to do with it.
See, that's all hearsay. Just because he said he's got this expertise, it's opinion. It's opinion. How can you make opinion
Mr.
true?
Jakubowski, hearsay is out-of-court statement made by someone.
Okay, I'm not going to listen to how you manipulate words.
All right.
An opinion is opinion. Opinion is not truth. How can you use opinion in court?
Well, Judge, I think his problem is with an expert can testify via opinion.
The expert can testify.
And it's just an opinion.
Yes, you're exactly correct. And the jury will be instructed that they can accept his opinion or not accept his opinion. They're not bound by his opinion. They will make that determination. That's part of the
Well,
jury.
it shouldn't even be evidence.